Good afternoon, sir. Both Balaji sir and Ranjit sir. Very good afternoon.
How are you?
Doing well.
Is there?
Good afternoon, Ashwini. Nice to see you after a long time.
Yes, after a long time, sir. Likewise, very nice to see you, sir.
Thank you. Thank you for accepting our invitation and also for your consent to deliver a lecture on a Saturday.
Anytime, sir. It's a pleasure to be back at law school.
Nice.
Sri Lanka is coming back to normal, Sima.
Yes, sir, it is. I mean, we've just had a new appointment of a prime minister, but although not all factions have agreed to his prime ministership, we will see how things are. But in terms of the economic crisis, that will take some time to stabilize, sir. But as far as politically, there is a new appointment, and the cabinet also, they are expecting new appointments will have to be made in the coming days.
Yes, Nivedita.
Yes, ma'am. Mahatma Gandhi once said, keep your thoughts positive because your thoughts become your words. Keep your words positive because your words become your behavior. Keep your behavior positive because your behavior becomes your habits. Keep your habits positive because your habits become your values. Keep your values positive because your values become your destiny. A very good afternoon to one and all gathered here today in this online platform for the international workshop on understanding the legalities of data protection and their impact on businesses, organized by the Department of Business Law and the Department of Cyberspace, Law and Justice. I'd like to first thank our Honorable Vice Chancellor, Tamil Nadu Dr. Ambedkar Law University, Professor Dr. N.S. Santhosh Kumar, sir, for providing us with this wonderful opportunity. Thank you, sir. Now I introduce Dr. Kumudaratna ma'am, Director, Postgraduate Courses and Head of the Department of Business Law, School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University.
I'm going to give a welcome address.
Over to you, ma'am.
Sorry. Thank you, Nivedita. First of all, a very pleasant afternoon. I won't say warm afternoon, a pleasant afternoon to everybody who's already joined in this audience, and also those who are in the process of logging in. I can see many people are trying to log in. Welcome to them also. First and foremost, a very cordial thank you, a very grateful thank you to our Vice Chancellor, sir, because it is only because of sir's motivation that we're able to have so many programs. We need not even think about whether sir will agree or anything at all. If it is an academic program, immediately we are certain that sir will encourage us and give us all the, help and everything at all. Thank you very much, sir, and a very cordial welcome to you, our Honorable Vice Chancellor, sir, Dr. Professor N.S. Santhosh Kumar, sir. And nextly, Ashwini. Ashwini is from the third batch of the School of Excellence. And one common feature of all our students, alumni, is whenever we call them or invite them for any program, immediately, instantly, they will accept. Even Ashwini, a late evening, I will say late night itself, that is when it struck me, I should call Ashwini, invite her for a program. I only FB messaged her. I didn't even have her number at that point of time. And immediately she responded. In fact, today she's got another meeting, entire day's meeting with another corporate firm. And as she was conversing with me itself, she sent a mail to them saying that meeting should be deferred. And by next morning, she said that today, 2 p.m., we can have this program. So that is the enthuse with which our students, I won't say alumni or alumnus, our students come in here. Thank you very much, Ashwini, and a very joyful welcome to you. Welcome back to your academic home. That is what I would say. And also to our registrar, a very gracious welcome to our registrar, Dr. Ranjit Omen Abraham, sir. And he is a 3-in-1 today. He's the registrar. I'm welcoming him as registrar. And also he is one of the organizers. I will say he's doubling up as an organizer because he's a member of the Department of Business Law and also the head of the Cyberspace Department. A very joyful and cordial welcome to you, sir. And our Dean, a very most pleasant welcome to our Dean, Professor Dr. Balaji, sir. I say pleasant because whenever anything, I repeatedly say this, whenever we see something as an issue and go to it, to him in a very pleasant manner, as if that issue was not there itself, he will resolve it. And time and again, I say, I should learn how to do that, but it is a magic, it's an alchemy, but I don't know whether I learn even before I retire. Thank you very much, sir, and a hearty welcome to you. Next is our controller of examinations, Dr. Srinivasan. He is very busy, especially now when exams are going to come, but still he's promised that he will be joining this program at a later point of time. A very bright welcome to our controller of examinations, Dr. Srinivasan, sir. A warmest welcome to our Director, Research, Publications and Academic Affairs, Dr. Haritha Devi. And again, she is also one of the organizers of this program because she's a member of the Department of Business Law. Thank you very much for all the help, ma'am, and also being here now. And a very friendly welcome to the Director, Undergraduate Studies, Dr. Boneshwari. I say friendly because our friendship is going back to almost 30 years now, having joined as one of the first law faculty in this institution. A very friendly welcome to you, ma'am. And also a very courteous welcome to our director, IQAC. She is one of the senior most professors. I won't say one of the senior most professor in this institution. A very courteous welcome to you, ma'am. A sincere welcome to the Director Campus, Dr. Ashok Kumar. He is also the head of the library wing of this institution. A hearty welcome to you, sir. And my special welcome to the principal of the Madras Law College, Pudupakam, Gauri Ramesh ma'am, and also Jay Gauri ma'am, principal of the Vellore Law College, and also Vijay Ramalingam, I say Vijay Lakshmi Ramalingam ma'am, principal of the Chengalpet Law College. They have already joined and some are already in the process of joining. Thank you for making time in your busy schedule and taking part in this program. A very hearty special welcome to all the 12 heads of the department. In our Tendalu, we have 12 departments, and I'm certain that all the heads will be logging in. A very glad welcome to each and one of you. A cheerful welcome to all the colleagues of this Tendalu institution. This means not only the institution here primarily, but also colleagues from various affiliated colleges in this state, the Tamil Nadu. And also students, this program itself is for you only. A very hearty welcome to you. I'm certain that this program will be very useful to you. I'm not only saying from the point of view of the title and all that. See, Ashwini is your senior. See how she's come up, and she's also a member of the government bodies in Sri Lanka. This should be an impetus, an incentive to you, a motivation to become like her and even more, and know that all this is very much possible, though you are now in the ranks of LLM and UG. And also a very thankful welcome to all the admin colleagues from the PG department, and also Mr. Darwin, Mr. Joy, and everyone. A very hearty welcome again to each and every one of you. I'm sure that you will be very appreciative of the program because it will be of much utility to not only law people, but people from every strata of this society. Thank you, one and all. Over to you, Nivedita.
Thank you, ma'am. I now invite Professor Dr. Balaji Sir, Dean Faculties and Head of the Department of Maritime Law, the Tamil Nadu Ambedkar Law University, to give the felicitation address. Over to you, sir.
I don't know what to say, whether warm or cool, whatever it is. That's a very wonderful afternoon. Where just a minute. In fact, at the outset, let me greet the Department of Business Law and the Department of Cyberspace Law and Justice now for conducting this international workshop on understanding the legalities of data protection and impact on business. Welcome Ms. Ashwini Natesan, that is a legal consultant researcher, who is also our alumni. I'm very happy to see her once again. She's in a very respectable position now in the member of Law Reforms Advisory Committee, also in Ministry of Justice Sri Lanka, and Madam Kumaratna, the Director, Postgraduate Course, and my colleague and Registrar, who is a multifaceted personality now in this program, Ranjit Abraham, and Anita Devi, Madam, who is the Director in charge for research and publication, the moderator Nivedita, and Akshaya, student coordinator. As I said, that it's a program which is very important indeed, and it's the one other thing what I have seen in this is the two departments are coming together. That's a very fascinating one, where the Department of Cyberspace Law First program is also that. I congratulate Abraham sir for that. And in fact, it is a new beginning. That is actually another department is coordinating, and they are making use of this both the things. They have come up with a perfect title. That is a welcome trend that all the departments should do. The other way, they've shown the trend also to do that. And I cannot say much on this thing and data protection and their impact on business. But however, it was interesting to note that a few hours before, myself and Haritha Devi madam were there in another program, which was being conducted online by ICSI, the Institute of Company Secretaryship in India, the institute, which have been making a program on data, digital India. That was the thing. I think Haritha madam is there, who is also witnessing along with me. And in fact, an eye-opening session was there given by one of the speakers, where he has given a wonderful data that how India is fast growing and how the technology has been helping, and it is almost it is we cannot even imagine that how fast we have grown, and has given collected a very interesting data that how we use Indians use the mobile phone, and we are almost fifth place in all India global level, where we are using the mobile, every individual using a mobile phone for almost 5 hours continuously. Is India's the fifth position, and Brazil seems to be the first. Anyway, on the other side, the digital and the other technology, and in fact, that is almost closely coming with this topic, the data protection, is a must. That what, in fact, I was also hinting on the other side that the technology grows on one part, the other danger, other things also on the other side, where the other things is also growing on the same level where the danger exists. So that is how what is given a hint. But here exactly that's a point where how the data has to be protected when the businesses started growing. And there are several facets when I see the topic. I don't want to go into that, but I really congratulate the departments who have chosen this topic, which is the need of the hour. And once again, I congratulate all the persons who are involved in organizing this program. And once again, I'm happy to see the our alumni is there, and hope she will also give us inputs about how the things has to be there, and some solutions how to protect our head. So with these few words, I happy to see everybody over here, and thank you for giving this opportunity. Thanks.
Thank you, sir. I now invite Dr. Haritha Devi ma'am, Director, Research Publication and Academic Affairs, and also the Head of the Department of Environmental Law and Legal Order, the Tamil Nadu Dr. Ambedkar Law University, to give the felicitation address. Over to you, ma'am.
A very good afternoon to one and all present here, respected Dean, Registrar, Head of the Department, ma'am, and all others present here. First of all, I congratulate both the departments. As sir has already told, it's a new beginning. I think combination of two departments doing seminars, I think we have started. So maybe Kumar ma'am is the starting point for many things, right? Thank you, ma'am, for that. And I think the title, Understanding the Legalities of Data Protection and Their Impact of Businesses. And very, very happy to see our own alumni to talk on that topic. I think thank you from on behalf of all present here, Ashwini. Nice to see our alumni there. Definitely, this brings in, I would say, to all the students here, would feel somewhere a confidence will come to all the students that yes, we also can achieve something. We will be there tomorrow. Yes. So giving that confidence by the alumni is very, very important. So I think it's wonderful to see you here. And the data protection, in fact, today businesses are facing the challenge of data protection. In fact, We cannot avoid collecting the data, but at the same time, how to protect it. And where lies the balance is the most important thing to every businesses will be facing. And younger generation, in the sense, as sir has already told, India is ranking 5th or 1st or something like that. Younger generation is now in a state that they cannot avoid being digital. So that's sure. So no going back. It's like catching hold of the tail of a tiger. We have already caught. So we cannot come out of it. Only thing we have to see how better we can do and how better we can protect it, as well as taking care of our privacy, taking care of our human rights, etc., etc. So that's what maybe I am very eager to hear from the expert here. So I don't want to go into the topic. But today's generation say that, I mean, if you ask their mobile phone, they won't give because they'll say it's privacy, it's my privacy, and they'll put locks and all and keep. But unfortunately, they will take a photo and post it in the, what to say, Facebook or WhatsApp or their status. That too, every minute there will be status. I am here, I am going there, I am coming here, etc., etc. But they will say privacy to own parents. But the whole world is actually seeing us, and I think people who use Google will understand. Every week, Google itself will tell where all you went. So that means somebody else is watching you, right? So data protection becomes that much very, very important, a hot topic, I would say, and very, very need of that. So let me not proceed. I congratulate all the team, the entire team, especially Kumaratna ma'am and Ranjit sir, for having organized such a very, very vibrant topic. I'm also eager to hear. Congratulations. Thank you once again.
Thank you, ma'am. It gives me great joy introducing this person to each and every one of you. She's a legal consultant and a researcher specializing in technology, media, and telecommunications law. Ma'am is a member of the Law Reforms Advisory Committee of the Ministry of Justice at Sri Lanka. Ma'am has completed her master's at the National University of Singapore and is also a part-time lecturer. Moreover, with great pride, I'd like to mention that she is an alumni of our institution, and during her time as a student, she's participated in various national and international moot court competitions and has won many laurels to our institution. With great pleasure, I now introduce our chief guest and keynote speaker of today's event, Ms. Ashwini Natesan. Over to you, ma'am.
Thank you very much for the very kind introduction. And first and foremost, my sincere thanks to Honorable Vice Chancellor, to respected Registrar Sir, to respected Dean Sir, to Dr. Kumuda Ratna ma'am, especially for inviting me, to Dr. Haritha ma'am, and to all the other professors who have joined in today, and all the students. Thank you very much for joining in today. It is indeed my delight and privilege to be a part of today's event and discuss an area of law that I personally find a lot of interest in, and I hope that you would also find today's session useful and interesting. I'll just start sharing my screen.
Other than the speaker, all of you kindly turn off your mics.
Niveda, I hope you can see my presentation.
Yes, ma'am.
Thank you. So today's topic is on data protection and its impact on businesses. It is an overview, so I must say that within the given time of about 40 to 45 minutes, I will try to cover as much as I can. And apologies if you have certain areas that have not gone into detail, but I will do my best to cover the basics involving this area and also go into certain legal provisions which are necessary to understand data protection. Before we move any further, because this is essentially a workshop, it's important for us to look at a scenario and apply it in line with the law. So let's see Raji, our friend here. Raji can be you or me or anybody. So here what happens is Raji signs up for a new online platform. It can be your Amazon. And she has, of course, shared her personal details, such as name, address, occupation, etc. She frequently shops for bags. That's what she really likes to do. After a few days, what she sees is all her recommendations on the page, the home page, relate to bags, because of course the algorithm has understood that that is interest. Not only that, she also sees ads relating to bags in other platforms. Let's say when she's visiting other websites or even on Facebook and on Instagram, that's what she's seeing. But what's interesting here is Raji is a resident of Chennai. She lives in Chennai. Her data is being processed in Singapore. And the company, the online platform where she buys all of this, is based in London. You can understand the nature of this transaction, that it involves various jurisdictions and a data of a person sitting in another jurisdiction. The technicalities behind this is what I hope that you will be able to unbundle by the end of today's session. And not that I should be able to, but you should be, and that is my endeavor. What are the learning objectives? To start off, I want to draw the distinction between data protection and the larger concept of privacy, and to also understand the basic legal terms used in data protection laws as a whole. We will be focusing on some jurisdictions, including India. You'll be learning about the comparative international position and, of course, understanding the impact on businesses. What should businesses be doing in light of a data protection legislation? So let's start with some basics. What is privacy? A question that many of you would be confronted time and again. It was once remarked by US Supreme Court Justice Louis Brandeis that it is the most comprehensive of rights and one that was being valued by civilized persons. But really, that doesn't tell you what is privacy. So there is no one single universal definition for privacy, and which is why I have quoted well-known author Daniel Solove when he says, privacy is a concept of disarray. Nobody can articulate what it means. Really, there's no one way of putting what privacy is. But we understand privacy to mean either in terms of a spatial concept where certain spaces are considered private. It can also be an institutional concept where we have certain relationships that are considered private. And there's also a decision-making privacy where you are able to make certain decisions. All of these encompass the larger gamut of privacy. But in today's session, we are not going to be focused on the larger issues of privacy, but our focus will be on data privacy or data protection, which is relating to informational privacy of personal data, your personal data, and the protection thereof of it. That will be our focus. When I say data privacy, it is centered around the concepts of storing of data, collection of data, managing data, and the sharing of data with third parties, and the necessary legal compliance that is necessary when personal data is collected. So that will be our focus for today. But as lawyers, I understand that we are often confronted with the question of why. Why should we be concerned? And for data protection, as was very rightly mentioned by both Dr. Balaji sir as well as Dr. Harita ma'am, that this is a topic that is so essential for us. There is really no need to overemphasize it. Any application or app that we use, any websites that we look into, or any service that we are obtaining online or even offline, data is being used. Data that can be your phone number, data that can be the details of your Aadhaar card, data that can even be just your name. So all of these pose important questions First, the question being, what is the data that is being collected? How secure is this communication? With whom or what entities is my data being shared? And what are the purposes for which my data is being used? Today's session, I want you to think of you being the data subject, that is your data being shared. That's on one level. And secondly, from the point of view of businesses, we will be focusing on both. Because at the end of the day, not only you are a subject, that is your data is being shared, but you will also be advising entities, business entities, in looking at it. And there can be no more appropriate way to present today's session rather than one that is being conducted by both the departments relating to business and cyberspace, because technology law or technology itself is interdisciplinary in nature. There's no one way to look at it, and you need culmination of various subjects to be able to understand the concepts relating to it. And that is why I think it is an excellent that the both departments have come together for today's session. Having said that in mind, the question that most of you must be having is, what is the data that is being collected? Now, I've been saying the word data so many times. You can ask me what data? Well, for starters, you have to look at the terms and conditions, the privacy policy. And you all know that. That will let you know about the data that is being collected. But instead of looking individual platforms, in today's session, our guidance will be the various national legislations, the laws of various countries. And that is how we will be proceeding to understand the legalities surrounding data protection. And in the next few slides, we will be looking at the positions, that is the applicable laws in India, in the EU, in the US, and in China, and in other South Asian countries. But before we go there, some of you may wonder as to why we have to touch on international laws. Why do we have to look at laws in other countries? In every respect of data protection, no country can work in isolation. It is always a work between several jurisdictions. Let's go back to our friend Raji and the example I gave you. She is signing up, of course, in Chennai. She is a data subject, that is a person whose data is being collected, situated in Chennai, but the processing takes place in Singapore, and the company that is collecting this data is located in London. So there is no argument better to say for data protection that it is something that we look at for various jurisdictions. And companies constantly look at various jurisdictions to make sure that their policies comply with the laws of other countries. So keeping that in mind, what is the position of data protection in India? We all know of the celebrated Justice K.S. Puttaswamy versus Union of India decision. And in that, privacy was, of course, recognized as a fundamental right. But beyond privacy, like I told you, today we are looking at data protection. As at date, India does not have a comprehensive data protection legislation. What is available is a sectoral protection. That is, for certain sectors, you have protection, be it telecommunication or health. I've given an example on the slide relating to reasonable security practices and procedures and sensitive personal data or information rules 2011. Those are the regulations that occupy the space as at date. But there was an effort to bring about a codified law, and that started way back in 2018. In 2018, a committee of experts were constituted, and they drafted a first draft of the proposed data protection law, and the revised version was submitted in 2019. But this 2019 version was subject to a lot of discussion, and then it was decided to send it to the Joint Parliamentary Committee. The Joint Parliamentary Committee submitted their revised draft of what was then called as the Personal Data Protection Law, and now it's called as the Data Protection Bill. So in today's session, we will be again focusing on the Data Protection Bill of 2021. based on India. That will be the legislation we are looking at. So I'll only look at this bill and not the other sectoral protection, mainly because of the paucity of time that we have. Another very, very important development internationally has been the General Data Protection Regulation applicable in the European Union. As I already mentioned, no country can function in isolation because of the nature of the metaverse or cyberspace, which is why we need to understand the principles applicable in other jurisdictions or other regions like the EU. The GDPR is a comprehensive data protection framework, and it applies to processing of personal data. It covers both private sector as well as the government, and it's a rights-based approach. We will be seeing some of the rights that the GDPR guarantees. And you will also understand that knowing the GDPR is like the gateway to understanding the laws that were passed after the GDPR, because many countries, and I can give you examples like China, Brazil, or even Sri Lanka, have all looked at the GDPR in forming their laws. So that has been the model that they have followed in coming up with their own legislations. What about the United States? Again, the United States does not have a federal level general consumer data privacy or a data security law. What it has is some state level laws. And at the federal level, they do have the US Privacy Act, but that looks at restrictions on US government agencies as opposed to consumer data privacy related rights. That is covered within state laws. The one that most of you will be knowing is the California consumer privacy legislation. But you have other states like Virginia and Colorado and New York that do have similar legislations. And I have put in a link in the notes section. Of course, the slides will be made available later on. You can see further in the notes section. I've given some links that you can look at if you wish to see more. You also have China, which has a personal information protection law, which is again modeled after the general data protection legislation of the EU. This came into effect in 2021. And in South Asia, including where India is, you would understand that India also does not have a comprehensive legislation. Sri Lanka recently enacted the Personal Data Protection Act in March of 2022. And it's the first country to do so in South Asia. But you do have other countries who are looking to pass their own legislations, be it Pakistan or Nepal or Bangladesh. So having those international perspectives in mind, let's consider to whom or to what kind of data are we looking at? Okay, what exactly are we protecting? And who is this data protection legislation that we are going to be talking about? Who is it going to protect? First thing, data protection legislations protect personal data. India's bill, that is the data protection bill that I told you about, is slightly different from others, that it not only protects personal data, but also protects non-personal data. But before we go into non-personal data, let's consider what is personal data. In the most simple terms, personal data is data relating to any natural person. So it has to be an individual. So we're not talking about corporate persons. We're talking about natural person. And they can be either directly identifying or indirectly identifying any characteristic, any trait or attribute of any person. So a direct identifier, as the examples I've given you, can be your name. It can be your phone number. It can be your address. But you also have indirect identifiers. Let us say I say a person living in Chennai 18 and in this particular lane, in a house that has pink color paint, in an apartment called this. This will indirectly help to identify a person, even without going into the specific details of that person. If I'm able to indirectly connect to that person, that would also be covered within personal data. So data protection legislation protects personal data, and this is what personal data means. The Indian legislation, that is the bill, looks at protecting also data that is non-personal. And since we can talk for days just about personal data, I'll not be going into non-personal data in great detail. Also because of the fact that the distinction is not very clear. And what we have is now certain indications to say what will be non-personal data, but not much beyond that. But it'll be interesting to see how the law will get shaped up when it comes to non-personal data. To give you a comparative perspective from the GDPR, which is the General Data Protection Regulation in the EU, personal data means, again, it's similar to what India has also put forth. So India has also considered provisions of the GDPR and made some changes to it. So again, it refers to an identifiable natural person. It can be direct or indirect identifiers. And then here they give you more details. It can be your name, it can be your identification number, it can be location data, it can be an online identifier. Let's say you're in the metaverse, you have an avatar, and that online identifier can go to say many of your details, personal details that can also be considered your personal data. It can be pictures because physical, psychological, genetic, biometric, social identity, all of this fall within personal data. I mentioned biometric. You will all think of personal data as data relating to you, but surely you will all agree that there is difference between your health data, that is your health reports and information that can be more sensitive, and that of your name, because we are willing to disclose our name, but we certainly are not willing to disclose our bank account details or our health reports to anyone. So the laws identify that. And there are different requirements that must be fulfilled for sensitive data. In the Indian context, that is the Indian bill refers to it as sensitive personal data. But if you look at the General Data Protection Regulation, they would refer to it as other categories of data. What is sensitive personal data? It can be your financial data, it can be health data, it can be data relating to your sexual orientation or biometric data. That is the retina scan, the fingerprint. All of this is sensitive personal data because the consequences or the ramifications of disclosure of this data can certainly have a more pronounced impact than disclosure of any other data. Okay. And in the GDPR, it's similar to what India has, but you have to remember the GDPR does not state financial data to be sensitive personal data, but India has classified sensitive personal data to include financial data. And we also have another category in the Indian Data Protection Bill, and that is called as critical personal data. But what is critical personal data? It's not yet been defined, but you need to remember that there is also another additional category relating to data. I'd like to pause here and just mention that in understanding data protection laws of any country, now my endeavor is at the end of today's session, you understand the general legalities concerning data protection laws. And no matter which country you look at the laws, you should be able to understand the basic concepts. You would have learned that when it comes to laws, they apply within the jurisdiction. So it is very territorial in nature. That is the structure of laws. You take the penal code, you take any other law, it will be applicable within that particular country. But we understand that the cyberspace or the metaverse is not only one jurisdiction. And you cannot say that it would only apply within my country. There is necessity to make it applicable outside of the country. Only then will there be effective enforcement. Only then will it make sense. Let's go back to our example, our friend Raji. I told you that she is signing up for the service in Chennai, yes, which is in India. But her data is being processed and being controlled by someone outside of the country. So does it mean that the Indian law cannot apply to Raji? Can it be said that, oh, but it's not within the country? That was the case some decades ago. That would be the impression that anyone would get. But with the GDPR and several other legislations like that, the application of data protection is extraterritorial, and we call it extraterritoriality in its nature, which means that if the processing of data takes place within India, processing can be anything. It can be accessing data, it can be storing data, it can be even just running and keeping the data for subsequent access. Whatever it is, all comes within the definition of processing. Okay, so when you see the word processing, think of it as the whole gamut, from access to retrieval to storage to anything of data. So if the data is processed in India by an Indian company, yes, this law would apply. Similarly, if the processing of personal data by any person under Indian law, if the Indian laws are applicable, obviously it will apply. Yes. Hi. Is there a question that Nishant had? Nivedita, was that a question?
I don't think so, ma'am. I think they've only turned on. You can carry on.
Okay. But please don't think that I did not mention it. You can, of course, interrupt me at any point in time, and please make this as interactive as possible, because it's a workshop and not that I intend to hog all the time and just keep speaking. So coming back to the issue of, or the concern of, extraterritoriality, it is insufficient to only say that it would apply to those in India or when the processing takes place in India. In our example, Raji's data is being processed outside of India. Will the law be applicable? Yes, the law will still be applicable, because in this particular legislation, it clearly states that even if the data fiduciaries, you'll be seeing who these persons are, even if the data is being processed outside of India, if it is being processed within India, that is, they may be outside, but they are doing business in India, then you have to comply with our law. You want to offer business to Indian nationals, then please comply with our law. That's what this is saying. And this is not that only the Indian law is saying like that. The GDPR in 2018 had created quite an uproar with many jurisdictions saying, why should we look at applying our laws to the GDPR? But they were very clear in mentioning that if you are operating in the EU, that is, if you are offering services to people in our region, please make sure that you comply with our laws. And India too has followed suit in their bill, making sure that the application is extraterritorial and not only within the country. Okay. And the second point is, of course, profiling of data principles in India. We'll come back to it, time permitting, a little later. So we had seen some jargon in, that is the legal jargon relating to data fiduciaries, processors, etc. So we'll just kind of untangle that and in very simple terms explain who is who. First, let's look at the data protection bill in India. In that, a data fiduciary is a person who determines the purpose and the means of processing personal data. So we are talking about a person who has control over that data. You sharing your details to the online platform, or Raji sharing the details to an online platform, something like Amazon. Amazon is the data fiduciary because they are the ones who make the decision as to how your data is going to be used and what are the purposes for which your data would be used. And then you have a data processor. Who is a data processor? Someone who processes the data on behalf of the data fiduciary. See, the data fiduciary, that is the data controller, can be someone like Amazon, but they may not be processing the data. They may have data centers in various countries to process that data. Those persons, that is those entities, are referred to as data processors. And what about individuals? Individuals are referred to as data principals. That is the natural persons whose data is being collected. So this is how the Indian bill defines the who is who. But to give you a comparative picture, we'll also be looking at how that would be considered in the GDPR. In GDPR, they are called as data controllers. Data fiduciary is your data controller. Data processor is the same. Data subject is the person who we call as you and me, the data that's being collected from you and me. can be referred to as, we can be referred to as data subjects or data principals. In addition, we also have definitions for whom we call as significant data fiduciaries. So essentially, when they process large volumes of data, like for example, your social media platforms, they would be called as significant data fiduciaries within the context of the Indian law, okay? But in understanding data protection or the principles of data processing, this is a very important slide that I just want you to leave with. How do we process data, or how does an entity, that is the business, process data? Okay, I see a question on the chat box. Thank you for that question. But if you give me a minute, let me just finish with this and come to the question that's on the chat option. So we look at principles of data processing, and this we are looking at it from the angle of the GDPR, which is the General Data Protection Regulation. First, it has to be lawful. Any processing, that is any use of data, has to be lawful, it has to be fair, and it also has to be transparent. The next one is purpose limitation, which means that you have to limit it to the purpose for its being collected. The next one is data minimization. Only collect the data that you need. That is, this is for the companies to keep in mind, and don't collect all sorts of data. Make sure that the data that's being recorded is accurate. And storage limitation, store it only for a particular period or when it is necessary. And then integrity and confidentiality. That is, it has to be maintained in a manner that can not be subject to, or at least try to ensure that you have sufficient practices to make sure that the data can be maintained in a confidential manner. Okay, so these are some of the principles of data processing. Years ago, you would see that when we look at entities looking to comply with data protection principles, they would be throwing in concepts that you have to have a certain type of data processing, it has to have certain security standards, it has to have certain technical standards, etc. In today's times, this is the reality where we all have to make sure that whenever data is collected by companies and by entities, these requirements are borne in mind, which brings me to the next section on its impact on businesses. See, businesses today rely on data, and there's a cliched sentence you would have seen at various places about data being the new fuel. And I would say data is the fuel that runs businesses today. You have businesses run entirely through data, and the value of data cannot be overstated. Really, it is that important. So when we look at managing data from the point of view of businesses, what can they do? The first cardinal principle of data protection is to make sure you have customer consent. You can process data once you have the consent of the customer. There can be instances where data can be processed without consent. Before we go into that, I'd like to pause upon the necessity of making sure the consent is informed, specific, clear, and also one that can be withdrawn after it's given. See, because when we look at businesses, yes, they need data. But how can they go about collecting that data? It would have to be ensured by taking the necessary consent. And that consent, being informed consent, is quite obvious. But what we generally see when we look at the various social media platforms we are on, and also other services that we take, there is a checkbox. We just check it without really reading the terms of that consent or the privacy policy, because we enter into so many such contracts on a day-to-day basis, we really don't read everything. And I would say me included, till I started working in this area. The importance of that is for us to be sure that this is what we are ready to share, and this is the data we need to share. But you can also tell me, but we really don't have a choice. I want to be on this platform, so I have to agree to their terms and conditions if I want to get access to that particular platform's services. That is true. And that's why the law comes in. You can't leave it to the businesses entirely. The businesses are not only making sure that they follow the law, but the law will also bring in checks in place to make sure that certain type of data are being collected. And that's why you have the principles like purpose limitation, data minimization, to make sure that you collect the data. Yes, you obtain consent, but that is not the free pass. That is not only enough. And before we go into sharing or using of data without consent, I'd like to just stop here and say that if we check into any service or start using a service, take a minute to read the terms and conditions and the privacy policy. It is also the endeavor of businesses to make sure that the privacy policy is in simple terms. The legalese, as we call it, has to be simplified. Only then can it reach the end customer. So as lawyers, if any of you are advising businesses and drafting their privacy policy, remember, moving away from very complicated legal jargon is what all businesses want today. If you are on Twitter, a few days ago, you would have seen that there was an update on their privacy policy. And the reason being that you know that there's going to be a change of ownership. And they had, in very clear terms, said that they have tried to keep away from the very complicated legal terminology and tried to keep it as simple as possible. So for businesses, that is another important area that they must keep in mind. What about using data or processing data without consent? Can it be done? Well, it can be done, and it can be done for public interest. And in terms of public interest, we talk about when state needs it for certain purposes or through court orders for some medical emergencies or pandemics, disasters, all of this you can use. And the other one being legitimate interest of the data fiduciary, that is the data controller thinks that it is necessary for certain interests based on the sharing of data, that can be done. And also whether it can be reasonably expected. Now, all of these are from the Indian law. In the notes section of the PowerPoint, I've also shared the legal basis of processing from the GDPR. You have consent there too, and they have something called the performance of contract. They too have a legitimate interest. And similar to our public interest, they do have vital interest. They also have legal requirements and public interest in itself. So these are the grounds for processing of data. Coming to the role of businesses, and I saw some questions relating to privacy by design, etc. So some of those will be looked at in this particular next few slides. The first being, they have to, that is data fiduciaries, controllers, these businesses will have to comply with certain requirements. These are the obligations placed on them by the law. They can in best practices have even more stringent practices, that's fine. But at the very minimum, first, they must have a notice mechanism. What is this notice? This notice is when they inform the data subjects, that is the persons they collect data from, the various purposes. What are the purposes we're going to use your data? What is the data that we're going to collect? Because I told you personal data, what is included. So they'll tell you exactly, or they should tell you, the businesses must tell you as data subjects. Or they would also make sure that they have simple policies or notices which cover these various aspects that I've mentioned in this slide. They'll also include the rights, etc. And we'll be just going into them into some detail. But there's one point that I would like you to kind of be mindful of, and that being grievance redressal. It's important to have a mechanism according to the law for grievance redressal. If there is a data subject and you are the business, the data subject is not satisfied with the explanation given to you or the given by you, then there has to be a way to resolve that grievance of that particular data subjects, and that's something that the businesses must bear in mind, and any other relevant information. In addition to notice, there are several other requirements that must be fulfilled, and we can have sessions just on each of them. Some being purpose and collection limitation, quality of personal data, data retention, accountability, privacy by design, transparency, data breach reporting, which means whenever there is a data breach, the businesses have to give a notification that there has been a data breach so that the data subjects will be aware of it. Third-party processing. So in the example I gave you of Raji, the case study, the data is being processed in Singapore, which is a third party doing the process on behalf of the data fiduciary or the data controller, as we call them. That those contracts should be in place, and they should also have security measures such as de-identification, anonymization, all of that. And we also have to bear in mind that personal data will no longer have the character of personal data if all the necessary information, see, for example, the personal details relating to the particular transaction, let's say your name or the person's occupation or the person's pictures or whatever it is, if all those are removed, all the personal data is removed, and you only have the symbols X in that place, it's no longer personal data because the personal identifiers have been removed. So when we take the personal identifiers out, it would be referred to as non-personal data. And remember, I told you that we'll do a little bit on non-personal data. And that is when you have de-identification and anonymization. Your data, when it's no longer personal, and when it has been removed, the personal identifiers have been removed, and instead you have symbols such as XXX, YYY, like that, it can be called as anonymized or de-identified data. That would fall within the category of non-personal data. And non-personal data is not subject to data protection regulations in general. But in India, you have another category for which certain regulations would still continue to apply. So I'll just leave it at that. So now, again, from the point of view of businesses, you have to give certain rights to your data principals, that is data subjects. Raji, our data subject or data principal, has to be given certain rights because it is her data, right? So what are the rights that should be given? As under the Indian bill, the rights are confirmation and access, that Raji is able to confirm and also able to access her data. She is able to correct and erase the data. So there is something which is incorrect, she can correct it and also erase that data. And very importantly, the right to be forgotten. Yes, the purpose for which she has joined that platform, maybe today she decides that I no longer want to get this service, I want to stop being on that particular platform. She can specifically ask that her data be deleted, and that is the right to be forgotten. Data portability, and this relates to what we call as automated decision making, or when you use automated means to make a decision, let's say through AI, ML, certain decisions are being made. And for that, to get your data in a structured format and also to be able to bring it to you in a mission readable format, that is data portability. And exercise your rights, you have to exercise all your rights and of course have grievance redressal as data subjects. As data subjects or data principals, when our data is being collected, all of this should be given. But from the business's angle, they have to have policies in place and make sure that these rights are available to the data subjects or data principals from whom they are collecting data. It's not that they can do as they please. They have to make sure that they have all of these controls in place. And before I go into the last few slides, cross-border transfer of data. Data, like the cyberspace, is not only confined to certain geographical limitations. It travels far and wide. And there is also necessity to travel for the data to travel, like in the example of our friend Raji that I told you about, where she is using a service in Chennai, but the service provider, that is the data controller, is elsewhere. Obviously, her data has to travel so that they can provide that service. So what happens to cross-border data transfer? And when you look at cross-border data transfer, you will see that if data is being transferred from one country to another, there needs to be certain requirements that are to be complied. There is no real restriction on data transfer, but they have to make sure that the conditions relating to data transfer are satisfied. And what are those conditions? And those conditions, we call them as adequacy decisions. And there's a case law that I would be discussing with you. Cross-border data transfer itself is a specialized area in data protection that we do a lot of research on. where you have concepts such as data sovereignty, data localization, etc. So maybe in the Q&A, if anyone is interested, I'll be happy to throw some light on that. So you have a requirement to have your data within the country. That is called data localization. In the Indian bill, you don't have such a requirement. You can transfer data, but of course you have to make sure that the conditions relating to safe transfer of data are met. It's not different from the GDPR. The GDPR also will have these requirements that needs to be fulfilled, and we call those as adequacy decisions. I can see that there are several questions in the chat box that are popping up. Just give me a few minutes. I'll wrap this up, and I'm happy to take all your questions. And then moving forward to the Indian legislation, that is the proposed bill, that also has requirements similar to that of the GDPR. All right. And we look at cross-border data transfer of sensitive personal data. So the only requirement that this bill has imposed is that they say that you retain a copy of sensitive personal data within the country, and you can transfer. But when you transfer, what you must do is make sure that it is subject to certain requirements, and they've mentioned those requirements. The only prohibition or restriction that they have when it comes to data transfer is critical personal data. And like I already mentioned, what is critical personal data has not been defined. So we'll wait to see what it is. So that is something that we are able to look at from a cross-border data transfer perspective. But we also have the requirements that businesses have to follow, and one such is appointment of a data protection officer. This is for at present, the requirement is for significant data fiduciary, not for every small controller, but you have for significant data fiduciary, they must appoint their own data protection officer, and that person must be from a senior position, and they must be having a key managerial role, and they have to perform these various functions relating to data protection. And of course, the DPOs, data protection officer, must be based in India. Any data protection legislation you see, there will be certain common elements. The common elements are a data protection authority and the requirement to have a data protection officer. They may not insist on data protection officer for all types of controllers. Some may say some laws may say for only for bigger companies there needs to be one, or some laws may say for the smaller companies they can have a shared data protection officer. Okay. Keeping that in mind, which this brings me to the point that I was mentioning about on some important case laws concerning data protection for businesses. And I have focused on 3 case laws that are outside of India for some relevance. And the first one, I am quite sure many of you must have read about it, and that's the Schrems II decision. What happened in the Schrems II decision? See, this is called as the adequacy decision. After the GDPR, the General Data Protection Legislation, to transfer data from one country to another, there has to be what we call as an adequacy decision to say that, yes, EU data is being shared outside of EU, but the other country should have adequate privacy laws. Only then can we transfer the data. So in the Schrems II decision, they said that the laws in the United States were not sufficient. So what happened was, without going into the legalities of this particular decision, they said the privacy shield, which was in existence between the EU and the US, which allowed for data transfer, they said that is not compliant enough of GDPR. You have to enter into standard contractual clauses to make sure that data is protected. That's what happened in Schrems II. And in Lloyd and Google's case, which was from last year, quite again widely reported in the media from the UK, where they said on class action. Okay, so it's not quite common in our parts of the world, but in the US and in the UK, you have many class actions that take place for violation of tort, etc. In this, they said that the point of showing that there has been a damage or wrongful use of data and what was the damage that caused to that entire section of people, was not sufficiently proven. That's why that did not succeed. So it doesn't mean that class action suits won't work for data protection. So let me just kind of flag that point to you. And then Google LLC versus the CNIL, which is the Information Commission in existence in Spain. It's an interesting decision. So what had happened was, here we talk about the geographical limitations. And they said right to be forgotten. Yes, you have to apply it within the EU, but the territorial scope of right to be forgotten is only within the EU. You can't say that Google has to make sure that the right to be forgotten is exercised in every other country, because we're talking about the GDPR. We have to make sure that within the countries of the GDPR, yes, you can exercise the right to be forgotten, but it would not extend beyond that particular limitation, is what they said. So those are some of the decisions. And before I wind up in the last few minutes, I know I've gone 5 minutes over time, and I hope that's okay, ma'am. I'll just take another few minutes to quickly wind up the presentation and go to questions, which is certainly the more interesting part.
Take your time, Ashwini. It's not that quickly. You can take your time.
Okay, thank you, ma'am. So we now come to the point of the challenges for businesses. As persons who are studying business law and as future lawyers, you would understand that data protection is certainly going to have a huge impact on businesses, and it is already having a huge impact. More so, it will be in the days to come, or in the years to come, because of the proposed laws that would be taking effect in India and in various other countries, as you already saw. The first is on compliance cost. As you can see, there are lots of requirements that are imposed on the controller, that is the business, and they must make sure that they follow those requirements, and significant costs will be involved in that. And we refer to this as compliance cost in general. So yes, that is something that businesses would have to look at. And there can be businesses that are exempted from the legislation, and that's also something that the Indian law is looking at. But for data-driven businesses, and increasingly so that we have many of these data-driven businesses, this is certainly something that they would have to make provision for. The next one is availability of persons with expertise. Like I already mentioned, when we look at data protection, it's not strictly law, or it's not strictly technology. It's an integration of law, technology, and it's a compliance function where you need persons with expertise, and to recruit and have those persons in the team is again something that businesses can sometimes find as quite challenging within their own resources. And could it be a barrier of entry? Would it mean that because of the huge costs and the very sometimes complex requirements, could it mean that we are only making way for the big businesses, the big tech companies to thrive, and we are making sure that the smaller players are sent out? That is something for all of us to think. And you have many writings that go on to focus on the necessity by saying that, yes, that could certainly be a reality, and we have to look at solution that would also make sure that the smaller players are not driven out. And regulation, or leading to technology limitation. What happens when there is no regulation? When there is no regulation, of course, technology can function and develop in various ways. And we all would agree on one thing, that law certainly never keeps up with the technological developments. Technology is always far ahead, and law takes a while to catch up. But having said that, would having regulations in some way affect the nimbleness of technology, or would it bring about certain barriers for technological developments? Again, an area that needs to be considered, and it's obviously an argument which has a lot of merit. Reputational damage. See, this company, for example, in Raji's case, the company decides that because at present, India does not have a law. So they think that, okay, if Raji is writing to me, that is the company, they think that Raji is writing and asking for data to be deleted. Well, I will not delete her data. And there has been a data breach, which means there has been leak of a lot of confidential information, personal data. It can be just email addresses and names. Still, there has been a leak from that company's side, and they have not complied with this request. They didn't have to do it because India did not have a law at that time, but still there would be significant reputational damage. So yes, every country is material to a business. They cannot say that let me suffer reputational damage in one country and only follow the laws of one country. If you think the GDPR is important, the Indian law that is forthcoming is equally important. So there's no question of thinking that they would follow one jurisdiction and not follow the other. And of course, the last point, loss of business. Not only reputational damage, but there can be significant impact in losing the confidence of the users. The users are the most important persons here because your data subjects are the ones who are fueling your business. They are giving you the data. And if they believe that their data is not secure, their data can be shared with anyone and it could be subject to a leak, in that case, certainly there would be loss of business. And a few years ago, you may have seen a lot of people decided to sign out from Facebook following the Cambridge Analytica issue. So when things like that have popped up time and again, there have been several data breaches. And of course, there has been an impact, a real world impact to it in terms of loss of business. And so, yes, this gravely affects businesses. In addition to the areas that we have discussed, there are other several areas of relevance when we look at the legalities concerning data protection, and those are automated decision making, fully automated or partially automated in the laws relating to that, exceptions to the application. And we did a little bit on anonymized and pseudo-anonymized data. Well, that is also something that we can go into further detail. And on penalties for non-compliance, there are many penalties. And in India, for example, the bill does not have a specific quantum on all areas, but they do mention about the higher brackets extending to even about 150 million or 4% of total worldwide turnover, etc. So that's the extent of penalties we're talking about, and enforcement by Data Protection Authority. A Data Protection Authority is your regulatory agency for data protection. Of course, we don't have the time to cover all of that, but in the Q&A session, I'm happy to address questions relating to it. And giving you some concluding thoughts. For businesses, it's not the question of, well, I will either thrive well in business or protect data. It is not a zero-sum game. In my opinion, it is really a win-win situation. You are able to have a business that's thriving as well as protect data, because it is no longer a choice between either or, it should be both. And there is necessary for businesses to adopt and adapt their legal terminology in a way that is easily understandable to data subjects, to everyone. And it's a way to promote citizens' rights for the data that they own, because it's ultimately their own data. And through this entire presentation, you may have got the impression that we are focusing only on businesses, okay? But we all know that the state and its agencies cover a large part of our life, and they collect a lot of data. So there is necessity to make sure that these data protection principles apply to the state. Yes, they have certain exceptions, but doesn't mean that the state can be made to stand on a higher pedestal where they do not have to comply with these requirements. And of course, the law cannot be made in a day. So there has to be incremental development of law. Keeping that in mind, even the Indian bill, they say that there would be at least about 18 months time that should be given so that businesses would have the time to comply with these wide-ranging requirements that the law poses, okay? So I'm going to leave you with this image and let you all know that no matter what it is, no matter what data you are sharing, please make sure that the use of that data is in line with what you believe is actually the use. You may think, oh, I only thought of this, but do ask the questions. And many times the answers are there in the privacy policies and of course in the national legislation that looks at the subject. Okay. So, and of course, if any of you wish to connect with me on LinkedIn to have further conversations in relation to data protection, I'm most happy to do so. All right. So with that, I will just stop my presentation and of course, look at the questions that have come up. I am done. Thank you for your patient hearing, but of course, this is not the end. And I always look forward mostly to the Q&A session. That's where all the interest is. So you may agree, disagree, whatever it is. I'm happy to take all your questions. Thank you so much. And let's open the floor for questions. Niveda, should I just look at the questions or will you be reading out the questions? What would it be like?
Thank you, ma'am. The other student coordinator, Ms. Akshya, will be reading out the questions to you. You can answer.
Thank you.
Shreya? Is she there?
There are lots
If
of
Akshaya is not there, you can carry on, Nivedita. Nivedita.
Yes, ma'am, I'll read.
Oh,
The
she's
first
there.
question, ma'am, is how to run GDPR compliant giveaways on social media.
Right. Thank you, Shiva Shankar, for that question. So when it comes to GDPR compliant giveaways, each GDPR, as you can see, is the rule or the regulation that applies to the entire European Union. So it's a regional level law. All jurisdictions within the EU, the countries of the EU, have to have their own laws based on the GDPR. So we have, let's say, the UK, you have the Belgium, you have the France. Each of these countries will have their own data protection authorities, and those data protection authorities have their information commission. And this data protection commission would make sure that they will give these guidelines through which you would have to make sure that those guidelines are complied with. To give you one example, there has to be certain security and organizational standards that have to be fulfilled to make sure that you are GDPR compliant. Let's say in the UK. So you have the ICO in the UK, and their website will give you information that will help you make sure that the website is being, or that particular organization is being run in GDPR compliant terms. I hope that is helpful, but please ask me if you have any other questions on that. I hope that was clear enough.
Thank you, ma'am. The next question is, do we incorporate privacy by design in our IT systems?
Yes. Okay, that's again a great question. See, privacy by design is one of the ways through which you can reach necessary levels of compliance. In the Indian law, the data protection bill, they do mention privacy by design. They do say that that is one of the ways through which you can be compliant. But it also depends on the nature of your business. If you're able to incorporate privacy by design, let's say for a messaging platform like a Signal or even WhatsApp, which has end-to-end encryption, that is fine. But when we are saying we need to incorporate privacy by design, we also have to know that there can be other situations where the data is required for law enforcement purposes. So that's a decision that the business must make. But yes, it is one of the ways through which you can be compliant with the necessary data protection regulations, and the Indian law specifically provides for it as well.
Thank you, ma'am. The next question is, what is your take on the right of data principles highlighted under the PDPD bill?
Okay, we did have a slide on the rights of data principles, and just to give you an idea behind that. See, the rights of data principles, that is data subjects, is central to any law relating to data protection. What the data subjects did not have in the past, it's being given to them at present. But it's not very easy sometimes to be able to implement those. Having said, we do have a confirmation and access right. There is a correction and erasure right, which in practice may pose problems because sometimes it may be removed from one system, but it's probably available elsewhere. So those are the implementation issues faced from the angle of the businesses. But from a data subject or the data principle side, I think we certainly need to have them. But the one right I'm not entirely sure about it's working is, of course, the right to be forgotten. we can say that the right to be forgotten or the right to delete data can work both ways. And to what extent would that probably play in real life is what we need to see. So, for example, a criminal can say that data relating to one particular conviction has to be removed. So, how are we going to face those concerns? So, that is ethical and sometimes even a legalistic argument in terms of right to be forgotten. That's one thing that I am also waiting to see how that plays out. There are certain decisions relating to it in other jurisdictions, but we'll see how it plays out in India and in South Asia, which seems to also have the right to be forgotten.
Thank you, ma'am. There's another question. Are
Sure.
we able to measure and demonstrate compliance with global data privacy regulations?
Yes, so that's again a very, very important question. So how do we know whether we are compliant or not? So we look at various standards through which we assess privacy. So for example, you have ISO 27001 as the standards, which are there. It's one of the standards. It's not the only standards, but we do have various such organizations that provide for standards to say that this particular organization has taken these requirements. And I think that's one way to show that your company is in compliance with these requirements. So having such international standards can really help for businesses to show that they are taking privacy very seriously. And like I mentioned, having poor privacy practice can be reputationally damaging, but having great and very robust privacy practices can also go a long way in adding to the credibility of the company. So it works both ways.
Thank you, ma'am. There are other two more questions.
Yes.
The next is, Google has been fined 50 million euros by the French data regulator in 2019 for the breach of data protection rules. Can the same happen in India under the Indian data protection rules?
So I'll answer this question on two levels. The first is it possible? Yes, it is possible. But what is the yardstick to know whether it's possible? It will certainly be dependent on the Data Protection Authority. How strong and independent is the Data Protection Authority? And to what extent does the Data Protection Authority able to enforce those the principles that have to be imbibed in any data protection authority? Are they able to actually live by those? And that's what we need to see, because in theory, yes, they are able to. And India is a very big jurisdiction. We have the power of data. And keeping that in mind, I do not think that they are not able to. Google certainly does not want to miss out on business opportunities in India, which is one of its biggest markets. So of course they would have to comply. And in the event that they are not complying, can they be a fine? Yes, the law provides that they can be fined, but the extent of to which they will be proactive in fining such companies would certainly depend on the Data Protection Authority and how their appointments are being made.
Thank you, ma'am. The next question is, do we have up-to-date records of all data processing activities?
Do we have up to, I am not entirely sure, Shiva Shankar, do you want to maybe expand on your question? Are you referring to any company? Should they have data processing records up to date? See, in India at the moment, we still are waiting for general data protection related principles to come into play. But if your company is collecting sensitive data, then like I said, the existing principles will have to you'll have to fulfill those principles. Yes, Shiva Shankar, please go on. I thought it unmuted. Okay. So like I was saying, but if you are looking at keeping a record of data processing activities, it's always good to maintain a record of data processing activities. And then another point related to data processing activities would be to make sure that you do have a system in place for what we generally refer to as a data impact assessment. And if you are venturing into a business which has which is reliant on data, let's say we call those as profiling of persons, or having to be able to afford certain more businesses that are data intensive, then yes, a data impact assessment also can preempt many of these issues.
Thank you, ma'am. Next question is, what is the
Yes.
role played in the data protection by Convention 108 and how countries are internationally bound by this convention?
Right. So just like any other convention, you would see that even the Convention 108 applies to those countries who have been signatories to it. And once you ratify that convention, and you're bound by making sure that due to your ratification, that is due to that country's ratification, they would have to have certain rules, certain laws in place to make sure that data protection is practiced in those jurisdictions. And to what extent are countries internationally bound? If you have ratified that convention, if a country has ratified that particular convention, yes, they should have certain data protection practices by virtue of that. But I must also add that even those countries that are not a part of Convention 108 are all racing towards having a data protection legislation. Why? Because of the fact that today, the data that your country is generating, especially in the larger jurisdictions, is of great value. So it is not only from a compliance of a convention perspective, but also from a business angle that data protection legislation, having laws relating to data protection, has become quite critical and central.
Thank you, ma'am. The next question is, do we know who and how to notify an impacted security breach? And within what period of time is an organization required to notify a supervising authority about a data breach with the realm of GDPR?
Right. Okay. So first, if we are looking at the GDPR relating to regulations relating to data breach notification, like I already mentioned, GDPR being the regulation applicable to all of EU, you have different countries, and each of those countries have their own requirements relating to data breach notification. So, for example, if you would see that in countries such as the UK, I'm going to just put that link onto the onto the chat box as well, because it's an interesting question. So what happens is in the UK, when you look at data breach notification, the ICO will tell you how exactly the notification has to be done. But the rule of thumb is data breach notification has to be given to the authority, also to the data subjects. Okay, and let's see here. In terms of report a breach, yes, this is the link. I'm just going to post that. So I've just used the example of UK here, but you can of course look at any other regulation that you would prefer. Yes, there is a timeline also relating to, just put this link onto the chat box. I hope that's useful. But about the timeline, see, again, the timeline would vary. There are jurisdictions which say about 24 hours within the breach, some which say immediately. As soon as you need to have the breach, you have to make sure that there is notification. But also quite important to keep in mind that every single breach, you don't need to report it. There are certain breaches where they have mentioned where there is significant loss, and those breaches have to. But as far as the requirement, best practice, we would always say that please report any breach that would have some impact. Okay, so in the UK, the time limitation that they give for this is about 74 hours, range between 48 to 72 in various jurisdictions. But as someone who would advise a client, I would say please do so once you are able to ascertain, because there's no point that you know of a data breach now. You certainly, the companies don't make that decision immediately. They always write to the lawyers and ask us about the requirements, and only then proceed to notifying. But what we do see is sometimes not notifying, there is really no point, because the people whose data has been breached, they will make sure that it is made known if it's at a large scale. So go by the law, but as a best practice, it's good for a company to be as transparent as possible. And now that's from the GDPR perspective. India also has a data breach notification. We are still awaiting further details relating to it. There are some data breach notifications which they think that in about 6 hours also that should be disclosed. So those are some of the areas that you can think of.
Thank you, ma'am.
Sure.
Next is, according to your point of view, do startup companies need to be drafted with high-end privacy policies, or should they have any different approach, especially with regard to standard GDPR clauses?
Okay, again, a very good question. See, for companies to have privacy policies, let's say the startups are based out of country which as yet is not having their own law. Or if they are delivering services to the EU, then they really don't have a choice. They have to have complied with the GDPR. But if they are not delivering services to any EU nationals, or they are not doing any businesses with the EU, then they have the liberty to construct a privacy policy at their own end. But a high-end privacy policy need not be a policy that is very complicated. And like I already mentioned, simplicity is the key. To be able to have a privacy policy that can be easily understood certainly would fulfill the requirements. And to be able to address simple questions that we would have as consumers. Put yourselves in the chair of a consumer and think, what is it that you want to know? What data is being collected? How is that data being collected? What is the purpose for which it's going to be used? Who are the entities to which with whom this data would be shared? So these basic questions, if we are able to address them, then yes, a simple policy in very simple English and also making them available in local languages is very important. But once there is a law, of course, the privacy policy has to be in line with the law.
Thank you, ma'am. The next one.
Yes.
With regard to BPO and night shift, who are collecting sensitive medical information pins like scam offering products, example, targeting USA old age persons, what is your point of view? Further, payslip is given to the working employees, and is it okay to pay tax and do scam? What can I take it as an interpretation?
Right. Okay. So in terms of collecting sensitive medical information, and especially if it is being targeted to the US, then this would have to be in compliance with the regulations of the United States, including the HIPAA. Okay. So if they are just giving out some products relating to targeting to all persons based on some data, then of course you would have to see based from what information was this given, number one. And second one, is it complying with the requirements of the HIPAA? Only then can we proceed with further. Is it okay to pay tax and do any scam? I am not entirely sure about scamming. I don't think any type of scamming is okay, but paying tax. See, tax is entirely a different part from what we are looking at. Our concern is in terms of data, but tax payment does not absolve you of data protection requirements. Data protection requirements certainly have a different place. So just because you're paying tax, it does not mean you will not be caught up within the requirements of data protection. Okay. But what I do see from this particular information, at least the question that I can read here is, it is sensitive personal data, but I don't know the nature of the company. Okay. If the company is coming within protected entities of the HIPAA, then certainly you must comply. But if it's some other company that's not coming within the HIPAA, it's something relating to consumer data, then of course you'll have to see whether the state laws are also compliant. So that's something that I would like to add here.
So much,
Maximum,
ma'am.
we'll have another couple of questions and then wind up, because she'll be tired.
Yes, ma'am.
Okay?
Yes, ma'am.
Yeah.
Yes, ma'am. The next question, ma'am. Is a comprehensive legislature is the answer for varied issues related to data protection? Could it be constitutionally valid in information era?
Okay. Again, that is another important question. See, the first thing as constitutional right. India already has the constitutional protection for privacy, which is the larger right. But data protection is in relation to having your personal data protected and the manner in which they can be used and proceeded with. So within the larger realm of privacy, yes, data protection comes, but is a comprehensive legislation the answer for all issues? Certainly not. There can be very many issues that arise even after having a data protection law, as we see in many countries. And when I speak to the lawyers based out of EU or in Australia, where they've had a data protection law for a very long time, they always say that it throws up many issues, many questions. And that's why it's important to have an independent regulatory body. And the Data Protection Authority, that's where they have a very central role. It is with the enforcement that the authority can bring in, can many of these issues be resolved. And another area that is quite related to what you have mentioned is there is the right to information. On one hand, you have right to information. On another hand, there is necessity to protect data. So the balance between these two should also be kept in mind by the authority that comes in for data protection. Yes, so I'd leave that.
The last question, ma'am,
Sure.
for the session. With respect to traceability clause, do you think it's appropriate for the government to mandate companies like WhatsApp to find the originator of a person who sends message, and is encryption really a threat to national security? Further, do you think traceability is proportionate to counter the issue of national security?
Okay, excellent question. Thank you for raising that. And see, we did have the intermediary rules in India that were passed last year, and that has been subject to a lot of debate. One such question was in relation to asking for the originator of a particular text or a WhatsApp message to be sent. On one hand, we have the requirement of protecting data, and we say, yes, please have privacy by design. But privacy by design, just I mentioned a few some time ago, that would automatically make it impossible for certain law enforcement authorities to be able to retrieve certain data, right? And so, in my opinion, traceability would, for something like WhatsApp, when their infrastructure itself is meant to be end-to-end encryption, would mean you have to re-engineer the entire system. So yes, that can cause significant concerns, and we are still at the crossroads of whether we need to have that. On the question of proportionality, see, we always look at the principles of human rights when we look at laws that are restricting any right, including surveillance, which is a restriction on your right to privacy, or asking for the originator details. So yes, they have to be proportionate, but in my opinion, for a simple WhatsApp forward that is sending information saying that, oh, if you drink rasam, you're not going to get COVID. Yes, certainly you are not going to be protected because you have rasam, but what's the point in getting the originator in that particular message? Is any person going to be suffering any detriment because they had rasam? No. Surely it's not going to protect them. Yes, it is fake news. Yes, but whether it is proportional or not is certainly a question of the facts. And for something like this, I do not think, like in the example, I don't think it's proportionate to say that for national security reasons, we should be able to trace, because national security also is a very wide concept. What can constitute national security and for which reasons can we be permitted to trace, again, is fact specific. So yes, national security is always an exception in legislations relating to data protection, including in India or including in other countries. But again, this would be dependent on how the Data Protection Authority is functioning and what they uphold as a valid reason for which data protection principles have to be absorbed because of the reason of national security. But I hope that helped you clarify.
Thank you, ma'am. And any further questions being posted will be shared to you via your mail.
Yes, I think there are a few more questions. So do I have to answer those questions?
We can forward you the questions via mail, or
sure.
yes, for you to answer further to them.
Definitely.
Thank you so much, ma'am. And I guess when I'm speaking, I'm talking on behalf of all my fellow participants that the entire session was very informative as well as educational. Thank you for taking so much time and patience, being so kind and answering each and every question for us. Thank you, ma'am.
Thank you very much. It was my pleasure. And I'm so happy to see so many questions because I wish I could answer all the questions. Certainly, it is my pleasure to be here because there's nothing like having students and others asking questions, because that is what helps us to improve and think beyond what we have prepared for in the presentation. So thank you so much to everyone who's asked all these amazing and thought-provoking questions.
Thank you, ma'am. Now I invite Dr. Ranjit Oman Abraham, Registrar and Head of the Department of Cyberspace, Law and Justice, the Tamil Nadu Dr. Ambedkar Law University, to give the word of thanks. Over to you, sir.
Thank you, Nivedita. It was really a great presentation by Ashwini, and after hearing such a great presentation, it's very difficult to propose a vote of thanks because it was really mind-boggling and a lot of questions and a lot of discussions, terminologies, data protection, data principles, data controller, data subject, and it was full of data. So anyhow, I thank my Honorable Vice Chancellor for allowing us and giving us this academic freedom to have this program, especially a collaborative program between the Department of Cyber Law and the Department of Business Law. And Kumada ma'am, special thanks to Kumada ma'am for choosing the right person on the right topic. And it was she who brought this idea, and we just processed it, and we were just waiting for the day, and today it happened. My special thanks to Dr. Balaji sir, who's our dean, who was given the felicitation address also. In spite of being a Saturday, I think this is the second program for sir. Special thanks to Harita ma'am, who's also one of our coordinators, part of our business law department, and also the director of research and publication. Special thanks to all the faculties who have come here from the legal academia. I have to really thank three principals of our affiliated college who have participated in this program throughout the program. Dr. Gauri ma'am, principal of Pudupakam College, J. Gauri ma'am, and also Vijayalakshmi Ramalingam ma'am. All of them have, in spite of the busy schedule and time constraints, they have made it pertinent to attend this program, and they have attended this program.
Thank you on my behalf also. Thank you so much, Gauri, Jai Gauri, and Vijay.
Also, I thank Rajalakshmi ma'am, who's attended this program, and she has not objected to Ashwini for using her name Raji, because we call her Raji in our university.
Okay, sorry. Apologies
No problem.
that she's not objected to it. Thank you, ma'am.
And also the students of both business law department and cyber law department and also the other faculties who have taken pains in designing the brochure, certificates, and also inviting students to participate. My special thanks to all of them. I don't know what to say, Ashwini. I still remember Ashwini as a student so many years before. I think I have taken cyber law for you.
Yes, it is all thanks to you.
And I remember taking class for data protection, where we discussed a little bit of data protection. From there till here, where Ashwini has grown to this level, where she has become one of the very, very important resource person on data protection, not only for Sri Lanka, but to many other countries, to many other universities. In fact, she's also a visiting faculty in a very famous international university. And also in many places, she's been invited to take classes and lectures and give her opinion. So to that level, she has come out, and each time when we hear about her, we are very happy. And today we were more happy to see her also while hearing about the whatever dissemination information what she has given to us. So I personally request Ashwini that she has to regularly lecture to the School of Excellence in Law students, because that's your, you are an alumni of our university. And maybe in future we can connect to the affiliated colleges also through video conferencing, and on very important topics you can surely come out well. When Ashwini told me that she's going to shift her practice from Chennai to Sri Lanka, I was a little worried. I was thinking that Ashwini would be growing up in a legal career in India. But she proved herself that even in Sri Lanka, wherever it is, she will be very successful. So that is her talent, her caliber. And I'm sure she will not confine herself to Sri Lanka, but she will be a very useful, resourceful person throughout the world. All the best, Ashwini, and thank you very much.
Thank you so much, sir. I'm indeed very touched by your kind words and those of the other participants who all sent their feedback. This means so much to me. And I must say, sir, that my foray into technology law started because at the law firm, I was the only person who had done cyber law. And they had seen cyber law was one of my modules, and they said we have to put her into the technology department at the law firm in Sri Lanka. That's how it started. So many thanks to you for being the mentor and the guru, and also for my masters as well. Sir was the person who I had approached for my recommendation. So always an example. He's led by example, and we are so blessed to be under your mentorship. And same with Kumuda ma'am, as well as Balaji sir. Both of them have
I would like to tell one thing, Ashwini. Actually, I would say I don't like to use the word unfortunate, but this batch was not, I didn't serve them at all because I was going for A section all the time in those days. And she so kindly invited me for her wedding. And that's when, knowing that she's one of the, really good students, I went for the reception, and that's how I got the connect. Thank you very much, Ashwini. In spite of not serving you all, inviting me, and now you're here. I was able to do this. Thank you.
Thank you, ma'am. Your notes, although we never had the good fortune of being under you, but we got all your notes and we used them quite extensively, I must say, in all the modules. So thank you for being our beacon
Thanks.
of knowledge.
So,
Thank you, dear.
Thank you, ma'am.
thank you.
Can we conclude the session, ma'am?
Yes, ma'am.
I thank each and everyone for taking their time and participating in this international workshop. For all those who have joined through WebEx, the feedback form link has been posted in the chat box. And for those of you viewing through YouTube, there has been the comment section where the feedback form has been posted. Thanks to everyone.
And one request here itself in the forum, you'll be coming here shortly, you told me, Ashwini, around 19th or something. I don't know when you'll be coming. We would like to have an offline lecture also, because LLM students classes are going on, in fact. So please do let us know.
Sure, ma'am.
Yeah,
I will
just an
let you know
informal
as soon
lecture.
as
That's
I
it.
get
Thank
my
you.
travel plans
Thank you.
finalized.
Yeah.
Thank you.
Thank you, Ashwini.
Thank you.
And also I have to thank Darwin, who's the technical person behind